You know that immediate, universal spike of anxiety you get when flashing red and blue lights suddenly appear in your rearview mirror? Yeah, we've all been there. Welcome to this explainer. Today, we're taking a completely objective look at the constitutional rights that actually protect you in those exact moments. Whether it's a random knock at your front door or a standard traffic stop, knowing the exact boundaries of the law is absolutely crucial for protecting your privacy. We're going to take some pretty complex legal doctrines and break them down into simple, actionable steps you can actually use. To make this easy, we're organizing your rights around 5 key areas today. First, we'll look at the knock and talk trap. Then, protecting your porch cameras, handling traffic stops and smell tests, defending your digital castle, and finally, we'll wrap up with the golden rule.
All right, part 1, the knock and talk trap. Let's start right at your front door.
Imagine you're just sitting at home and the police walk up your driveway to your front door without a warrant. You're probably wondering, wait, what legal authority even allows them to do this? Well, it's actually a highly effective investigative tactic that relies entirely on you cooperating. See, the courts have ruled that police legally have an implied license to approach your front door, literally just like any other member of the public would.
But here's the kind of terrifying reality of what happens when you actually open that door. Legal scholars often call these consent searches a black hole, where your Fourth Amendment rights just completely disappear. Why? Because the exact second you say, sure, come on in, the legal requirement for them to go get a warrant just vanishes into thin air.
An officer might tell you they're just looking for a friendly chat, right? But the actual goal here is to bypass the massive legal hurdle of going to a judge. And honestly, it works like a charm. In some states, over 80% of these encounters end up with homeowners unknowingly giving away their constitutional rights. Over 80%.
So, you might ask, where exactly does the legal boundary of your home actually begin? Well, the area immediately surrounding your house, we're talking your front porch, your driveway, your backyard, is known in the legal world as curtilage. Legally speaking, standing on your porch is treated exactly the same as standing inside your living room. The Supreme Court even backed this up in a case called Florida versus Jardines, basically saying police can't just casually stroll up to your curtilage with a drug-sniffing dog to snoop around without violating your rights. So what's the bottom line here? Unless officers have one of 3 very specific things: explicit consent from you, an exigent circumstance, which basically means a true life-or-death emergency, or a valid search warrant, they absolutely cannot force entry. In fact, you have literally zero obligation to even open your door. Okay, moving right along to part 2, protecting your porch cameras. When officers walk up to your house for a knock and talk, they're legally bound by the exact same social norms as the delivery guy or a neighbor dropping by. If an officer decides to cover up or disable your doorbell camera, that is a direct violation of your property rights. In fact, it could even be considered criminal trespass. I mean, think about it. That behavior wildly exceeds the normal, acceptable actions of a regular daytime visitor. So what do you do if officers are lingering on your porch, covering your cameras, or just refusing to leave when asked? Here is your playbook. First off, whatever you do, do not open the door or step outside. The moment you do, you lose the legal protection of your physical castle. Second, start recording the interaction from safely inside your house. And third, firmly demand that they leave your property immediately. If they decide to stick around and harass you without a warrant, they can actually be held civilly liable for violating your rights. That was set in stone by a major case called French versus Merrill. Now let's step out of the house and head to part 3, traffic stops and smell tests. Time to talk about your vehicle. Check this out because it's kind of fascinating. Courts all across the country have repeatedly ruled that the smell of alcohol alone does not actually prove intoxication. Do you know why? Because pure alcohol is completely odorless. When an officer says, "I think I smell alcohol," that's usually a clever interrogation tactic. They're basically going on a fishing expedition, hoping you'll get nervous, over-explain yourself, and hand them a confession on a silver platter. If this happens to you, you need to have this exact script locked and loaded in your brain. Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go, or am I being detained? Using this polite but very firm boundary completely stops the interrogation right in its tracks. It essentially forces the officer to legally show their hand. Are you officially detained, or are you free to drive away? Now, this smell testing also comes up a lot with marijuana, but the legal landscape here is shifting fast. Depending on what state you live in, the odor of weed alone might not even be enough to justify a search anymore. And here's a huge point. If you're just a passenger in the car, you don't automatically lose your rights just because the driver might be in trouble. Officers actually have to find separate, independent evidence on you, like clear signs of active drug use, before they can legally search you as a passenger.
Okay, here's one of the absolute easiest ways people accidentally hand over their rights during a stop: furtive movements. That's the legal term for sudden or suspicious reaching. So, say you're pulled over and an officer asks to see a firearm you're legally carrying. You need to keep your hands glued to that steering wheel. Why? Because any sudden ducking or reaching into your glove box gives them the exact legal loophole they need to say, "Hey, I feared for my safety," which suddenly gives them the green light to yank you out and search the entire car.
All right, moving on to part 4, defending your digital castle. Let's talk about your smartphone.
The courts completely recognize that your smartphone isn't just some piece of plastic and glass. It's in effect fully protected by the Fourth Amendment. It is literally a portable filing cabinet of your entire private life. Sometimes, during a routine traffic stop, an officer might casually say, "Hey, just unlock your phone real quick to show me you weren't texting." But listen, doing that voluntarily hands over the keys to your entire digital existence.
Instead, you want to state this clearly. Officer, I exercise my constitutional right not to answer questions about my private property. I do not consent to any search of my electronic devices. Saying it exactly like this is a real game changer. It de-escalates the situation objectively, keeping you totally polite and respectful while slamming the door completely shut on a warrantless digital search. Bottom line, no warrant from a judge, no browsing through your phone.
Which brings us to our final section, part 5, the golden rule.
0. That is the exact number of times you should ever voluntarily consent to a search of your home, your car, or your digital devices. None. Period. Because here's the thing. Giving consent legally cures almost any procedural mistake the police might have made leading up to that exact moment. You're basically bailing them out.
So your ultimate shield is this simple phrase: I refuse consent to search. Whether it's local police doing a knock and talk at midnight, an officer on the highway, or a federal agent asking to verify your firearms, these exact words are what you need. And you absolutely must say them out loud. Do not just stand there quietly, because sometimes total silence can legally be twisted into implied consent.
Now this brings us to the biggest psychological trap of them all. Cops are specifically trained to play on your nerves by telling you, well, an innocent person has nothing to hide, right? Don't fall for it. Asserting your rights isn't suspicious. It's exactly what legally protects you from an escalating, destructive search. Refusing a search is your fundamental constitutional right, and the courts have made it crystal clear. Using that right can never, ever be used against you as evidence of guilt in a courtroom. So, let's wrap this up into a straightforward 4-step action plan you can easily remember. 1. Stay completely calm. Keep your hands visible at all times and hit record on your phone. 2. Only hand over the legally required documents, like your ID. 3. Clearly and verbally state your refusal to consent to any searches. And 4. Just ask, am I free to go or am I being detained? By sticking to this exact script, you keep the encounter totally neutral. You completely avoid giving them any excuse to claim you were resisting, and most importantly, you preserve every single legal argument for your lawyer to use later. So armed with these exact scripts to defend your physical, your vehicular, and your digital castles, you're now totally equipped to safely and legally navigate these high-stress encounters. The Constitution provides a massive legal shield, but hey, you have to actually be the one to pick it up and use it. The next time an encounter tests your boundaries, will you confidently use your words to protect your castles? Thanks for tuning into this explainer, and always remember, your rights only work if you actually know how to use them.